Patriot Smoothie here on day 14 of the trial of Tamara Lich and Chris Barber in Ottawa. We just received Justice Perkins McVeigh's decision on the so-called admissions 2 argument, where the defense had put forward a admission that there was interference with the enjoyment of property during the protest in Ottawa. The Crown never accepted that admission and never suggested counter wording to that admission. Justice Perkins McVeigh deciding and ruling that they will dismiss the application by the defense to exclude the 8 Crown witnesses, which means the 8 Crown witnesses will be allowed to be called. That includes residents like Zexi Li and others. These witnesses will be speaking about basically who honked and when. The judge said that she will exercise her gatekeeping obligations as the trial management judge, as the trial judge, to ensure that only probative and relevant information and evidence is provided to the court, basically to exclude things that the defense calls victim impact statements, which will only be legally relevant and necessary at the end of the trial if and when there is a conviction on any of the counts of the information. Basically, there was a very heavy legal discussion. Justice Perkins McVeigh relying on several Supreme Court decisions, including one case referenced by both the defense and the prosecution, the Crown, in this matter concerning the role of trial management judge. It basically comes down to, if the trial management judge makes a decision that irreparably harms the prosecution's case, then obviously that's not something they can do. So that the Justice Perkins McVeigh agreed that if she were to step in and to basically decide against calling these 8 witnesses, it would irreparably harm the Crown's position, and that citing that it is case law in Canada, it's up to the Crown on how they wish to basically prove their case, to make their case. It's up to them how and when they proceed with their evidence, and they are not obligated in any circumstance to accept an admission by the accused. And also a citation where the accused is not allowed to frame their admission in a way that's basically it suits them and maybe disqualifies the Crown from being able to call other kinds of evidence that may be relevant that's not covered by the admission. So again, no obligation from the Crown legally to accept the admission from the defense and to basically say, okay, we're not going to call our witnesses now. They could have done that. They weren't obligated to do that. They're not doing that, and they won't be needing to do that. We will proceed with these 8 civilian witnesses, Zexi Li and others, Ottawa residents and Ottawa businesses, who will testify, as the Crown says, to prove that the protest was not peaceful, to refute the claim that it was a peaceful protest, and as well to prove the common and lawful purpose of the protest for the Carter application. These 8 witnesses will be used for the Carter application in that way, and as well to prove counts 1 through 4 of the information, counts 1 through 3 and 4 through 6, so basically all the counts. So they'll be used in many different ways by the Crown here. The Crown again arguing in their counter argument to the admissions 2 argument that if this was to go through, they would not be able to prove the accusations beyond a reasonable doubt. Their case would be irreparably harmed, and the justice agreeing, of course, with that decision, with that position here, by saying that it's not the role of trial management to basically step in and exclude Crown witnesses based on a defense submission that they're not obligated as the Crown to accept. So that's where we are here today, that these witnesses will be allowed to be testified. And we don't know if the Crown has changed their position on these 8 witnesses or not. Again, also remember that they will be subject to defense cross-examination. There will be an opportunity for Greenspun and Magus or Eunice and Granger to cross-examine these witnesses as the time comes to make the defense's case. And of course, there's going to be, I feel and I know that there will be a lot of emphasis on specifics. We're not going to have, I felt uncomfortable. That's not going to be admissible evidence as the trial proceeds, as we saw with Serge Arpin, former chief of staff to the mayor, saying that he felt uncomfortable or something like that, and the court basically saying, that doesn't mean anything. You need to give the time, the place, what you saw, who you saw doing it. You need very specific information that's observationally relevant as evidence into the criminal trial to prove beyond a reasonable doubt that a crime was committed. So far, in my lay opinion, there hasn't been good evidence provided to the court that a crime was committed. We saw videos of Chris and Tamara telling people to go shake police officers' hands. Sure, they said hold the line, but what does that even mean legally? As we heard from the defense, that means a lot of different things to a lot of different people. It's not some Hail Mary statement like, oh, go block this, go block that. That's not what we're hearing. We're hearing go shake police officers' hands, be peaceful, and you have a right to express yourself, which of course you do. And that's what it comes down to. You have a right to peacefully protest. You have a right to associate, and that a protest is a protest is a protest. There's no time limit on protesting, not by law. So And we also discussed how foolish it is to even consider this an occupation, an armed military takeover of an area, and to subject it to the local, to supplant the local authority with the occupier authority. That's not what happened in the Freedom Convoy. Trucks parked, they ran to keep themselves from freezing to death, and they honked their horns so the government would hear them. That's what happened in the Freedom Convoy. And we certainly have no evidence in this trial so far of any concrete criminality on the part of Chris Barber or Tamara Lich. For the rest of the day, I'll be providing you updates, as always, on Patriot Smoothie in Ottawa.